That finishes assault and battery and takes us to an always important category of crime, homicide. There are always dead bodies on the bar exam, and I have no reason to expect that there won't be dead bodies strewn about this time either, right? So it's important to understand homicide. Straight up, let's start with what's called the year and a day rule. It was true at the early common law that the death had to occur within a year and a day of the acts that caused the death. That has long been sunsetted in this country. Very few jurisdictions follow that anymore, so you can disregard it for bar exam purposes unless you're expressly told to apply it. Now, let's start then with homicide crimes. We have three major homicide crimes. We're going to start at the top, the important crime of murder. Now, on the bar, you could see them use the single word murder or the three words common law murder. Don't be thrown, they mean the same thing. Either way, the definition is the unlawful killing of another person with malice aforethought. So, big picture, murder is a malice crime. In order to demonstrate the necessary malice for murder, there are four different categories of mental state that can amount to malice, that demonstrate that kind of malice. So we're going to look at those four types of malice next. First, the intent to kill. The intent to kill. When you have an intent to kill, it's referred to typically as express malice. Example, Dudley points a gun at Victor, says, "I want to kill you." He then shoots and kills Victor, right? That's intent to kill murder. Malice is express. Second, the intent to inflict serious bodily harm. The intent to inflict serious bodily harm. So Dudley shoots Victor in the leg, intending only to maim him. Unfortunately, Victor dies from injuries related to the gunshot wound, right? So he doesn't intend to kill him, intends just to kind of mess him up really bad and overshoots his mark, right? Under those circumstances, there is those circumstances will allow the implication of malice. That's implied malice, and it works for murder. Third, extreme recklessness. Extreme recklessness, meaning reckless indifference to human life, right? Extreme recklessness, reckless indifference to human life. Many states call this particular type of murder depraved heart murder. So Dudley aims his pistol over Victor's head and fires, intending only to scare Victor. Unfortunately, the bullet hits Victor's head, killing him. That kind of fatal game is prototypical depraved heart murder. In the recent past, we've seen this type of charge play out in the city of Baltimore. The victim, Freddie Gray, covered nationally in the news, was subjected to a rough ride by the police. After he was arrested, he ended up dying as a result of during his transport from the crime scene to the hospital. Some of the officers have been charged with depraved heart murder, meaning that the prosecutor doesn't believe they intended to kill him, but those officers' conduct, subjecting him to the rough ride, not responding allegedly to his calls for help, demonstrated extreme indifference to human life and were extremely reckless, right? So that's, again, how that crime works. And fourth and finally, through the intentional commission of an inherently dangerous felony. We all know this as felony murder, intentional commission of an inherently dangerous felony. So Dudley robs a bank, he points a gun at the teller, the gun accidentally goes off and kills the teller. That's prototypical felony murder. Next up, felony murder. Felony murder is the second category, the second murder category with special rules. Now I want to start with a generic definition of felony murder. And that would be any killing caused during the commission of or an attempt to commit a felony. Now just think about that definition. Think about the breadth of that definition. That definition means that any time any defendant either succeeded in or attempted to commit a felony, and there are a zillion felonies in every criminal code, if someone ended up dead, then that crime, that homicide would be punished as murder, right? The highest level homicide crime, right? No jurisdiction that uses the felony murder rule, and that's the vast majority of jurisdictions in this country, none of them wants their doctrine to be that broad. Therefore, every jurisdiction limits felony murder in some way. It is equally true that no two jurisdictions limit it in exactly the same way. So where does that leave you? Well, what's important for you then to know and to apply on the bar are the most common limits that exist in this country on felony murder. Those are the ones of which you need to be aware. So we're going to turn to those now. First, the defendant must have committed the underlying felony, right? Makes sense. If you have a defense to the underlying felony, you have a defense to felony murder. Second, the felony must be inherently dangerous. It must be inherently dangerous. In this regard, a number of states enumerate the felonies that qualify for felony murder. That is, to be felony murder, it has to be in the course of certain specified felonies. When jurisdictions do that, they most commonly include burglary, robbery, rape, arson, and kidnapping. Those are virtually always included in the list. Also means that if you see a felony murder question on the bar for that reason, it's highly likely to be in the course of one of those felonies. Right? Third, what's called the merger rule. The felony must be independent of the killing, which means, therefore, that aggravated assault or battery can't be the underlying crime for felony murder. If it was, every time you committed an aggravated battery and somebody died, it would automatically morph into felony murder. Fourth, what are called the res gestae principles. The killing must take place during the felony or during immediate flight from the felony. During the felony or during immediate flight from the felony. Once the felons reach a place of temporary safety, the felony ends. Next, the death must be foreseeable. And finally, the victim must not be a co-felon. The victim must not be a co-felon. Dead co-felons don't rate, they don't engender a lot of sympathy, they don't have a lobby in the legislature, so they are squeezed out of felony murder in most jurisdictions. Now, next up, vicarious liability. The vicarious liability provisions of felony murder are very prosecution friendly, as we will see. So, there are two major vicarious liability theories that exist in felony murder in the United States. There's a pretty healthy split between the two. So the first, called the proximate cause theory, followed in some states, provides that if one of the co-felons proximately causes the victim's death, all of the other co-felons will be guilty of felony murder, even if the actual killing is committed by a third party. A third party, like a bystander or a police officer. Other states follow what's called the agency theory. And under the agency theory, the felony murder doctrine applies only if the killing is committed by one of the co-felons. Right? As I said, there's a pretty healthy split in this country between these two. Therefore, if it's important which theory applies on the bar exam, the bar examiners will indicate which theory applies, right, if that is important in resolving the particular question that they're asking you. So let's take a look then at the next hypo applying these felony murder rules, right? So Dumb and Dumber rob a bank. Dumber sits outside in the getaway car while Dumb goes into the bank, points a gun at the teller, and says, "This is a stick-up." And the following scenarios indicate who, if anyone, is guilty of felony murder. Well, first, Dumb's gun goes off accidentally and kills the teller. Right? Here, both Dumb and Dumber are going to be liable. Dumb directly, Dumber vicariously. They're both going to be liable. Second, a security guard fires his weapon at Dumb, but the bullet strikes and kills the teller instead. Well, under the proximate cause theory, both Dumb and Dumber are going to be vicariously liable. Under the agency theory, neither Dumb nor Dumber, neither of them is going to be guilty of felony murder because the shooter was not a co-felon. Next, the teller gives Dumb a bag of money, and Dumb runs outside and jumps into the getaway car. As Dumber speeds away, the getaway car collides with a police car racing to the scene. Both Dumb and the officer are pronounced dead at the scene from injuries sustained in the accident. With respect to the officer, Dumber is guilty. But with respect to Dumb, Dumber is not going to be guilty because Dumb is a co-felon, right? So there is that dead co-felon exception. And finally, 1 hour after arriving at their secret hideout, Dumb drives to Starbucks for coffee. En route, he runs a red light and kills a pedestrian lawfully crossing the street. Right? Who's liable here? No one. No one's going to be guilty of felony murder. Because remember, once the felons reach a place of temporary safety, the felony ends. Once they reach a place of temporary safety, the felony ends. Now, remember, in this question, what this means is that you can't use the felony murder doctrine, right? That doesn't mean you can't use some other homicide theory, right? If Dumb was driving recklessly, then you can use you can charge him with some other form of homicide, right? But not felony murder.